I want to clarify one thing. There is no requirement under this new rule that forces employers to pay higher salaries. The employers are required to comply with the LCA requirements. An LCA is a labor condition application, which is a prerequisite for an H-1B. An LCA mandates that an employer pay an H-1B employee a prevailing wage. That is mandatory. That does not change. And nothing about that LCA or the prevailing wage is changing under this new rule. So if you were competitive under the previous version of the H-1B rule, you will remain competitive under this new rule as well. Nothing's changing from that perspective. The only thing I would urge you to do is to make sure that you're following, um, taking steps to ensure all your immigration compliance pieces are aligned. For LCAs, your public access files are available because there will be more and more Department of Labor audits that I anticipate under the new administration. There could be site visits for smaller employers. If you're placing employees at third-party sites, then what is the difference between whether those employees being placed are the employees being placed on a small project, which is a discrete short-term project, or is it a long-term assignment where that employee becomes a part of that company's hierarchy and organizational structure, and you are providing additional talent to that company. So the requirements have changed in those two scenarios, but by and large, from a wage perspective, nothing has changed. So I don't think you have anything to worry from a wage perspective, but there are other things that you need to be mindful of.